Hello, everyone. I'm going to give people just a few seconds to click their links and load into the session. In the meantime, please see the chat for important information regarding your CE credit. Just a reminder to attendees, in order to receive your CE credit, please be sure to complete the post-session evaluation. That will be in your CE wallet in your TPN account sometime in the next 24 hours. Thank you for joining us for Legal and Ethical Considerations with Children, Adolescents, and Emerging Adults, presented by John Condren. My name is Michelle, and I will be your moderator for the session. I'm going to hand this over quickly to Deborah Lawton from Sandstone to take things away.
My name is Deborah Lawton, and I'm a therapist and clinical outreach manager here at Sandstone Care. I'm so glad you're joining us today. In case you're not already familiar with Sandstone, we provide a full continuum of care for mental health, substance use, and dual diagnosis treatment for teens and young adults. So we really focus on ages 13 through 30, as well as detox or withdrawal management and residential treatment for adults 18 and up. So we provide a full continuum that includes teen and young adult residential care, IOP, PHP, transitional living, alumni care, family groups. We got the full range. We've got locations in Maryland, Virginia, Illinois, and Colorado, and we get people from all over the country in our residential programs. Most important of all, we are in network with most major insurance carriers, including TRICARE and Kaiser. Happy to talk more offline about our services and your needs. I'll put some info in the chat for you. And now, without further ado, I'm very excited to bring you this training today. I really hope it's helpful for your work with children, adolescents, and young adults. So, John, it's all you.
Thank you. Um, hmm, didn't move. There it is. Greetings from Pocatello, Idaho. As you just heard, my name is John Condren. More than 40 years ago, I was lucky enough to attend a workshop. And I know many people will laugh at the idea that this was luck, but I was lucky enough to attend a workshop on legal and ethical issues in mental health by social worker Rick Reamer and attorney Robert Landau. They were so convincing, well, frankly, they scared me, that risk management and ethics have been a major focus throughout my career. I have also been lucky enough to work with some amazing plaintiffs' attorneys and ethicists over the years. I don't consider myself an expert on much of anything, really, but have learned a lot over the years and hope you can benefit from that experience today. We will review general risk management principles that apply to all populations, followed by a discussion of some of the complex dilemmas often faced by therapists working with children, adolescents, emerging adults, and their families. We will explore practical strategies to help prevent lawsuits and licensing board complaints. Key topics will include informed consent, age of consent, confidentiality, abuse and neglect reporting, and clients and parents' rights. We'll also talk about school law and a few other topics. I tend to overplan my classes, so we may not get through all the topics, but you will have my slides and my notes. Ethics classes are different in that they are supposed to encourage us to think and to discuss. Discussion is difficult in online classes. The last I heard, we had some very large number of people in this class. So, but there are ways to participate. One is to ask questions. Another is to respond when questions are put to you. Please, please, please help me to make this class into a two-way exchange of ideas, the way ethics classes are supposed to be. I am not an attorney or an ethicist and have never played either on TV. I will talk a lot today about laws, regulations, and precedents, but nothing I say here should be construed as legal advice. If you have legal questions, consult a licensed attorney, preferably one specializing in mental health law in your state. Let's start with the good news. Statistically speaking, your risk of being sued for malpractice or being brought up before your licensing board is relatively low. But even the most conscientious, principled, earnest, and ethical therapists run the risk that disgruntled clients or their parents might file complaints against them, even with little to no evidence of wrongdoing. Even though I've worked in some risky areas, including addictions, trauma, sex therapy, and personality disorders, I have never been sued, knock on wood, and have had only 3 licensure complaints in more than 40 years. Even though each of these was ultimately resolved in my favor, they cost me time, money, and aggravation. Some might call those dismissals luck, but I prefer to think it was because I have used the strategies we will talk about today throughout my career. As professionals, we have a responsibility to familiarize ourselves with the laws and legal codes of the states or territories in which we practice. Each of the topics listed on this slide could be a class of its own, but we will only have time to discuss each briefly today. By the way, I really hate it when presenters read slides to me. So I'm going to trust that you can read and just move on. Each of us is also responsible to read and understand the various codes of ethics related to our activities and to apply those principles to our day-to-day work. Remember, though, that the codes of organizations you have never even heard of can be presented as evidence in a malpractice lawsuit or licensure complaint, especially if it can be argued that you should have known about those standards. For example, if you render an opinion on what is, quote, in the best interest of a child in a child custody dispute, you might get an expensive and painful lesson on the standards for child custody evaluations published by the Association of Family and Conciliation Courts or the American Academy of Matrimonial Lawyers. Responding that you are not a lawyer will not save you. Saying that you have never heard of either organization will almost certainly make things worse. In lawsuits, ordinary people are held to what is known as the reasonable and prudent person standard. Professionals are held to a higher reasonable and prudent professional standard. That is what we mean by standard of care. Codes of ethics are often used to define those professional standards of care. We will discuss each of Dr. Rick Reamer's procedural standards of care listed here. Taken together, these are your best protection, in my opinion, against malpractice lawsuits and licensure complaints. For now, I want you to note 2 critically important words on this slide: consult and document. You will hear those words over and over today. Part of being a reasonable and prudent professional is to know or inquire about possible hazards or special duties and responsibilities unique to any, quote, special and potentially dangerous activity you might undertake. As they say on detective shows on TV, ignorance of the law is no excuse. You have an obligation as a professional to find out. Throughout this class, I will be recommending peer consultation as a risk management strategy. You might wonder if consulting with a colleague creates any risk to you as the consultant. The short answer is probably not. But I'll use this phrase multiple times today. The devil is in the details. Supervision is one of those special and potentially dangerous activities with its own possible hazards or special duties and responsibilities. So it is important to understand that peer consultation is not supervision. If a colleague comes to you for peer consultation, that probably does not create what attorneys call a duty of care, which is one of the 4 elements of tort liability. Unless, of course, you are their supervisor rather than a peer. So make sure that your relationships are well defined, preferably in writing. Anyone taking on a supervisory role should seek specific training in supervision and should also check to ensure that their professional liability insurance covers supervision. In my opinion, they should also be compensated for the additional risk, but that is clearly beyond the scope of this class. I would also add that if you do take a supervision training and they don't talk about the legal and ethical issues, find another training. Since malpractice claims involving children resulted in indemnity awards almost 3 times the average for adults and nearly 2.5 times higher than the overall average, working with children is arguably another special and potentially dangerous activity. Hopefully, you will never need to consult an attorney, but I suggest you identify one in your state who specializes in mental health law before you need them. You can seek referrals from other mental health professionals, but I found my attorney by reviewing the minutes of my state licensing board's meetings. I had to go back a few years, but I found a prosecutor. And generally speaking, well, the people they call prosecutors are local attorneys that have been hired to work for the board, as opposed to the elected prosecutors that you hear about in the news. But I found a prosecutor who had gone into private practice. She knows how the board works and thinks, and has been a wonderful resource to me. Every therapist should keep a few references close at hand. First, we should have ready access to the various codes of ethics pertinent to our professions, as well as to our particular activities. For example, a counselor should be able to lay hands on the ACA Code of Ethics. But if that counselor is involved in some specialized activity, such as mediation or child custody evaluation, they should also have easy access to the codes of ethics pertinent to those activities. Additionally, I recommend that every psychotherapist have ready access to Dr. Frederick Reamer's Risk Management in the Behavioral Health Professions. I think it's up to its 11th edition at this point. This is the most comprehensive guide I have found to date. I wish I could recommend an ethics reference specific to children and adolescents and emerging adults, but I found only one so far, and frankly, I found it disappointing. I won't name it here because of one of the first ethical rules I learned from my mother. If you can't say something nice, don't say anything at all. Of course, it isn't enough to have these resources on our shelves. When we consult, we need to document referring to these and other resources. One last thing about codes of ethics. They are typically written by well-meaning people who sometimes don't seem to understand how they might end up being used. My attorney friends tell me that even the legislators who write laws don't know what those laws mean until they have been interpreted by the courts. The same is true of codes of ethics. They are often kept deliberately vague, leaving interpretation to members of the organization's ethics committee. However, codes of ethics can be, and often are, used as evidence in malpractice lawsuits or licensure board hearings, where they might not be understood the way other mental health professionals might see them. The bottom line, when it comes to ethics, is we don't have to make the right decisions. We are allowed and even expected to make mistakes. In theory, the issue in a lawsuit or board complaint is not whether the professional used the best approach, but whether they used a reasonable approach that met the standard of care. What is critical is that we must document that we followed a rational and deliberate decision-making process. This is the model I use myself and with my supervisees. If you like it, use it. If not, there are many others out there. The important thing is that you as a professional need an ethical decision-making process that you apply and document consistently. The first step, identify the problem, is important. Before we can apply any decision-making model, we must recognize that we have a dilemma. That isn't always easy. Sometimes they sneak up on us. That is why regular supervision or consultation is important. If you only seek consultation when you think you have a problem, you may miss the problem. Again, regular consultation. Not to beat this point to death, but remember that good documentation can be a career saver. It isn't enough to make a good decision or to have a reasonable decision-making process. You need to document that process. Technically, the adage, if it wasn't written down, it didn't happen, isn't really true, but close enough. Documentation of professional consultations can take many forms. You could mention the consultation in a client progress note. You could do an administrative note, which goes into your own file separate from the client file. But by the way, that still might be discoverable in legal proceedings. My favorite strategy is to send a PHI-free email to the consulting professional to, quote, memorialize the consultation. This has the huge advantage that emails are time and date stamped. Of course, I'm showing my age here because this is almost certainly true of communications within your HIPAA compliant EHR platform as well. I'm just kind of inclined to use email because that's what I'm used to. If you use more than one of these documentation strategies, make sure they are consistent one with another. This has been a very short review of the general risk management strategies that apply to all mental health work, but these are not the focus of this workshop. If you have questions about the topics we've discussed so far, I don't plan to address them. I recommend that you take this free TPN class. The instructor, I've already mentioned him several times, Rhode Island College social work emeritus professor Frederick Rick Reamer, almost literally invented mental health ethics back in the 1980s. When I took that risk management class with him and Robert Landau, nobody was talking about ethics in mental health. He was taking concepts from biomedical ethics, which is where people were talking about transplant ethics and things, and he applied those to what he was doing as a social worker. He was groundbreaking. I still think of him as the dean of mental health ethicists, and I'm showing you here. We have a free 3-hour 3 CE hours course by Dr. Reamer that really is definitely worth the time. All right, moving on to issues specific to minors, or almost. That thing teachers tell students that if you have a question, there are probably others who have the same question, is especially pertinent to webinars like this one. Apparently, we have 730 people here, but this is being recorded and presumably will be made available to people in the future. Those people aren't going to be able to ask questions, so they are counting on you to ask their questions. Please click Q&A at the bottom of your screen and ask any questions that come up at any time. I won't necessarily stop and answer them in that moment, but I have scheduled some times to stop and try to answer questions. I will monitor the Q&A. I do want to remind you that I am neither an attorney nor an ethicist. So there may be questions I won't be able to answer. I would like to reserve the Q&A box for questions and ask that you use the chat box for everything else, including any snarky remarks you want to make about me. That's fine because I won't see them, so go for it. But especially, I'm going to ask you to respond to questions. We have 4 case studies that we're going to talk about today, and I'm going to ask you to use the chat box or the chat window to respond to those questions. All right, again, moving on to issues specific to minors. It is widely recognized that legal and ethical issues arise more frequently when working with children and adolescents than with adults. But very few resources are available on the subject. When I was asked to put this presentation together, I was shocked to find how little information there was out there specific to children and adolescents. So I am making these slides available to participants along with my notes, which I don't know, I've never seen anybody do before. My notes are very duplicative of what's in the slides sometimes, but that's okay. I want you to have everything that I found in my research. So, like I say, I'm not an expert, and this is far from a scholarly reference. Please don't treat it as such. All right, according to a 2023 counseling textbook, pictured here, counselors serving children and adolescents are called to balance the simultaneous and sometimes competing responsibilities to protect them while appropriately communicating and collaborating with the adults in their lives to enhance their development across the lifespan and promote their autonomy in developmentally appropriate decision making. In addition to being a horrible run-on sentence, wow, that's kind of huge. If I'd known that back when I took my first job working with kids, I might have listened to my mom and become an engineer. This is complicated stuff. I'm sure we are all familiar with Dr. Erik Erikson's stages of psychosocial development. It is important to keep these concepts firmly in mind when working with children, adolescents, emerging adults, and their parents. For one thing, we are often called upon to educate our clients, their parents, their teachers, and others about normal child and adolescent development. For another, we don't want to find ourselves in the position of explaining why we didn't. So, what is a child anyway? Some say a child is anyone under the age of 18, but that is far too broad a definition to be useful. According to the APA Dictionary of Psychology, a child is a young boy or girl between infancy and adolescence. But there are problems with that definition as well. For our purposes today, I think we can define childhood as the period before the manifestation of the psychological aspects of adolescence. But adolescence is also difficult to pin down. It is relatively easy, though possibly wrong, to define it as starting with the onset of puberty and ending with, quote, physiological maturity. But we now know that physical puberty can start as early as age 8, and brain development doesn't finish until the mid-20s. Does that mean that adolescence can run from 8 to 25? Is it useful to think of adolescence that way? The very idea of adolescence as a distinct life stage was a 20th century invention. The term was first used in 1907 by G. Stanley Hall, the first president of the American Psychological Association. For our purposes, the most important changes in adolescence are those listed here. As I said, a simple way to define childhood is by the absence of those changes. For example, children are incapable of abstract thought, though they can learn to parrot abstract ideas and often sound quite sophisticated. Children also tend to be very rigid in their thinking. In my experience, by the way, children with precocious puberty do not show those psychological signs of adolescence, though I'm not aware of any published research on the subject. If you are, please let me know. I'm easily reached, including through TPN Health. Like childhood and adolescence, the phrase young adult is used in different ways in different contexts. According to Erickson, it refers to anyone between the ages of 19 and 40. But depending on how you understand adolescence, it might not even start until age 23 to 25. In literature, young adult fiction is typically written for readers aged 12 to 18. So, young adult might be another useless concept, at least from our perspective. I would argue that the very existence of the book shown here, the Young Adult Survival Guide to Living Independently, argues for the validity of our next concept, emerging adult. According to Columbia University psychiatrist Mirjana Domakonda, 25 is the new 18, and delayed adolescence is no longer a theory, but a reality. In some ways, we're all in a psychological moratorium, experimenting with a society where swipes constitute dating and likes are the equivalent of conversation. This suggests that some of Erickson's stages should be adjusted back a few years to reflect current reality. The term emerging adult came along only about 25 years ago. It describes the time from the end of adolescence, whenever that is, to the young adult responsibilities of a stable job, marriage, and parenthood. Of course, that is problematic as more and more young adults put off or forego both marriage and parenthood. And more young adults are finding it very difficult to create a stable career, stable job. If you are inclined to reject the emerging adult concept, remember that there are still people who deny the idea of adolescence, calling it an unnecessary and artificial construct. All right. Even Erickson recognized that adolescence is sometimes extended. He called this a psychological moratorium. We know that Erickson probably did not, we know, but Erickson probably did not, that human brains aren't fully formed until our mid-20s. Today's teens are less likely to engage in adult activities like driving, dating, drinking, or using drugs than previous generations. So 18 to 23-year-olds may be legal adults, but are they really adults developmentally? Can we assume they are fully competent to make treatment decisions? Do they have the same range of experiences as their same age peers did 20 years ago? In 1978, Tom Beauchamp and James Childress identified 6 ethical principles common to a wide variety of professional codes of ethics: autonomy, beneficence, non-maleficence, justice, fidelity, and veracity. The only reason I read that list is that I'm convinced that one of the prerequisites for doing ethics classes is the ability to pronounce the word non-maleficence. Over the years, they have boiled those down to just the first 4, but I continue to find the longer list helpful in thinking about ethical dilemmas. We will use these as a framework for talking about ethical issues with children, adolescents, and emerging adults. I will present several case studies today to help us flesh out some of these concepts. I hate it when people read slides to me, but I'm going to do that because I found it in with the scenarios that it's just helpful. A mother brings a 14-year-old boy in for counseling, saying he, quote, he has anger issues because his father isn't around. Mother describes several angry outbursts at home and at school, while the boy sits in sullen silence. The last one resulted in the involvement of the school resource officer, who cited him for disorderly conduct. This is not the first time. Mother has been advised he will likely be sentenced to probation and ordered to receive counseling, and she wants to get ahead of that. The boy clearly does not want to be there and refuses to talk or even look at mother or therapist. Imagine that this therapist has come to you for peer consultation. Please click the chat box, not Q&A, at the bottom of your screen and share your thoughts on the legal and ethical issues presented by this scenario. What would you ask this therapist? What concerns do you have as the peer consultant? All right, I'm just going to start talking about this because I don't know what kind of responses we might be getting to this, but if I was the peer consultant, I would want to clarify legal custody. Is the mother the only decision maker? Where's the father? What are the father's legal rights here? Who is the patient? The boy, his mother, the court, the probation officer? Obtain the boy's assent to treatment, and we'll talk about that in a few minutes. All right, I have a question here. Has the biological father provided consent for this therapy? How do we know that the boy is angry about his father? How do we know that the boy, yeah, we don't know what the boy is angry about. We just know that he's angry. Has the child consented to treatment? And we'll talk about that in a few minutes. The child can't consent in many states, but he can give his assent. And we'll talk about the difference between the two. Does she have full custody? Yeah, or does she have full custody, or is it shared? In most states, in my experience, I do practice in multiple states. It is unlikely that it rarely happens that that one parent has full legal custody. It happens, but more often we see some form of joint custody. So we really want to know what the father's status is in all this. Is the mother seeking an evaluation of the boy that she will present to the court? I have to say the questions that are coming in are great because they are for the most part presaging, I guess is the word, the topics we're going to be talking about in this class. I would recommend learning more about the client's mood and presentation. Yeah, there's a lot we don't know at this point. All we know is that mom says he's angry because his father isn't around, and we know he's in trouble at school. How long have you been seeing this client? Okay, this one I can answer. This is the first meeting with the child. This is our first experience with both mother and child. But yeah, how often are the outbursts? How severe are the outbursts? A lot of times, again, research supports this, but my own experience, when school resource officers get involved, kids have a tendency to get into trouble more often. My concern is what is his perspective, the child's perspective. It's all about the mother at this point, which is often the case. A lot of times, well, in this case, the boy refuses to talk. So the only source we have is the mother. I'd like some specific details about the incidents at school. Yeah, absolutely. Child's reluctance and his own version of the presenting problems. All of these are really excellent questions. And that's your role as a peer consultant, to ask questions. And I'm going to move on because you've nailed it. You've nailed all of the points. Oh, the one thing I will say is if the boy won't assent to treatment, and we'll talk about that in a minute, it might be necessary to negotiate different goals with him from what his mother has presented. All right, so here are our common ethical principles. Which of these common ethical principles are at play in this case? Again, please put your responses in the chat box. As always, if you have questions for me, please put them in the Q&A box. That way we could, there's less chance of them getting lost. So what are the important issues here in terms of Beauchamp's and Childress's list of common ethical principles? Developing trust and confidence in the therapeutic setting. How to develop that. Hiltz and Luke said, we are called to balance the responsibilities to protect our minor clients, that's non-maleficence, while appropriately communicating and collaborating with the adults in their lives, justice and fidelity, to enhance their development across the lifespan, beneficence. Isn't that a great word, beneficence? And promote their autonomy and developmentally appropriate decision making. Okay, we have, yeah, autonomy, all of the above. Yeah, and it's interesting. All of the above is actually a really good answer. But the problem with these six these principles is that they often conflict one with another. So yeah, they all apply, but they may they may contradict one another. We have veracity, especially from the client's perspective. Is this kid sitting there thinking mom's lying about me? Is he sitting there thinking it's really a shame that mom believes everything that the resource officer says because he's lying about me? We don't know. Autonomy, fidelity, and justice feel like the most outstanding ethical principles that need to be addressed first. Autonomy, the child needs to have buy-in and say in his care. Really, all of these, but specifics are important. Yeah, absolutely. The devil is in the details. Just okay, I'm going to move on. As we all know, there are three elements of valid consent. The decision maker must be capable, and it must be both voluntary and informed. Generally, the law presumes that adults 18 or older are capable of making their own decisions unless they have been declared otherwise by a court. But is that always true? What about adults with mental illness? Can they always give valid consent for treatment? Can competency come and go? Obviously, it can. What about an adult who is strongly under the influence of another person? For example, someone with dependent personality disorder, or a 22-year-old who has never been away from home or made an independent decision. Are we taking advantage of them if we accept their consent when we have doubts? What about adults with developmental disabilities? Does an intellectual disability automatically render a person incompetent? Again, I'll provide an answer there. No. Who decides? Honestly, in our offices, we do, at least in the context of obtaining consent for treatment. client cannot give informed consent unless she is informed. The NASW Code of Ethics contains the most specific guidance on what this means. Therapists should use clear and understandable language to inform clients. And again, I don't usually like to read slides or read rules, but in this case, I think it's important. The purpose of the services, risks related to the services, limits to services because of the requirements of a third-party payer, relevant costs, reasonable alternatives, client's right to refuse or withdraw consent, and the time frame covered by the consent. We're all therapists here, and that list is numbing even to us. So can every client, regardless of age, understand all of that? If not, do they really have capacity to consent? By the way, is just having the client read and sign a consent document sufficient? No. Have you ever evaluated the reading level of your consent document? Do you routinely or ever assess the reading levels of your clients and or their parents? By the way, according to the National Literacy Institute, 2025, 21% of adults in the US are considered illiterate, and 54% have a literacy below 6th grade level. So that it ends up being a pretty significant issue. As a general rule, parents both consent for and have a right to information about their children's health and healthcare. However, there are some longstanding exceptions to these general rules that for different reasons authorize minors to consent for themselves and or control release of their own health information. It's important to recognize that even where the law authorizes minors to make their own healthcare decisions, parents and supportive adults still can play a crucial role supporting youth health. Research has shown that minors often choose to involve their parents and other supportive adults in their health decisions and voluntarily share information with them. We have to be really careful that our own experiences don't skew our beliefs about this. A lot of kids have really positive relationships with their parents and want to involve them in the decision-making process. Consent is explicit permission for something to happen, while assent is the agreement of someone not able to give legal consent. Assent is often communicated informally and non-verbally through nods, shrugs, or even grunts, but it should be documented for example, in our progress notes. It may be legal to treat a young patient without their assent, but is it ethical? The American Psychological Association and American Counseling Associations both say probably not. When patients are unable to give legal consent, psychologists and counselors are expected to seek the individual's assent and consider the person's preferences and best interests. Unfortunately, the NASW Code of Ethics doesn't even mention the word assent, except in the context of evaluation and research. I suspect that'll be fixed. I would argue that we always have an obligation to evaluate a client's capacity to give consent or assent, regardless of their age or circumstances. Capacity can vary with time and situation and should not be assumed, regardless of age. Someone commented, or if a person is under the influence or experiencing dementia, etc. Yeah, that's what I meant by competency coming and going. All right, this map was produced by the World Population Review and supposedly represents the age of consent for mental health treatment in each of the states in 2025. I advise you not to trust this map or any other resource, but to research the details of the laws and regulations in each state in which you practice. For example, I'm here in Idaho. Idaho does not, in fact, give minors the right to make their own mental health decisions at age 14, as indicated on this map. According to Holland and Hart, an Idaho law firm specializing in mental health, the most, anyway, here in Idaho, it's hard to specialize in one thing, but they have a pretty strong mental health component in their practice. The most conservative approach is to assume that a minor may not consent to their own health care unless the minor is emancipated. Generally, when attorneys say conservative approach, they mean if you do this, you're going to help me buy a boat, or more professionally, if you do otherwise, you may become a legal test case. Other states, such as Vermont and New Hampshire, allow minors to consent to various treatments provided it is for something specific and diagnosable. For example, New Hampshire allows 14-year-olds to consent to mental health treatment for sexually transmitted infections, and 12-year-olds to consent to mental health treatment for alcohol or drug abuse. Most states allow minors between 12 and 16 to consent to their own mental health treatment. Maryland lowered their age of consent for mental health treatment from 16 to 12 in 2021. Minors in Connecticut can receive 6 sessions of mental health counseling with no parental consent. There are 17 states that either require a person to be 18 years of age or older, or that make no law giving a right to consent to minors seeking mental health services. Of special note is California. The map shows that a 12-year-old can consent to outpatient mental health treatment or counseling, though she cannot independently consent to inpatient treatment, drugs, or psychosurgery. I've included this numbing litany of details only to illustrate the confusing mosaic of state laws regarding these issues. There is an excellent chance that some of what I just read is already wrong, because this is an ever-changing landscape. As I've said, I love this phrase, the devil is in the details. A California 12-year-old can consent to outpatient mental health treatment if, in the opinion of the attending professional, they are, quote, mature enough to participate intelligently in treatment and would present a danger of serious physical or mental harm to self or others without the mental health treatment, and is the alleged victim of incest or child abuse. First, this is very narrow, much more so than was implied by that map. More importantly, how would you, as the attending professional, make that judgment? How would you decide whether this 12-year-old is mature enough to participate intelligently? Would it require formal intelligence testing? If so, who would consent to that evaluation? Would you require a police report to document the incest or child abuse? That's actually a requirement in some states. Can you see how misleading the map in the previous slide was? As I started this slide, the devil is in the details. I see questions here. Asking for clarification on assent versus consent. Consent is the legal concept. Consent is legal consent. Assent is, all right, mom has consented to treatment. Does the kid agree? Does the kid assent to what's going on? Which is why I said it might be necessary to kind of negotiate with the child, and the child may have completely different goals of treatment, and then that brings you back around to the mom, because the mom has to consent to that. As I said, working with kids is complicated. If a parent wants the child to attend, but the child doesn't want to attend therapy, does that mean we should discharge the child? No, not necessarily, but as I said, it's tricky. It's going to involve negotiation with the child. Very often I find myself saying to kids, hey, look, your mom insists on you being here. I know you don't want to work on the things that she is proposing. You can just sit here and look at me if you want, but I would much rather that we do something productive with this time. What do you think? And I'm very often able to work something out with the child. Someone, I guess I've already addressed this, but who determines if they are mature enough? In Oregon, the age of consent is 14. However, at age 12, adults or parents can no longer access their medical charts. But here in Idaho, they just passed a law that went into effect July 1st of last year that gives parents complete and total access to everything and completely eliminates the child's right to make any decisions. So again, every state is different. This is why maps like the one I showed you a minute ago might be useful as starting points, but you have to be really careful because they can be really misleading. Not necessarily on purpose. Just it's really hard to keep track of all these different jurisdictions. This seems like as good a time as any to talk about the mature minor legal doctrine, which was first established by court precedent in Washington state back in 1967, when they found that some minors might be mature enough to consent to their own medical treatment. So in a way, the courts are trying to help us with these questions. Expert opinion varies about the extent to which the mature minor doctrine can be relied upon in the absence of an explicit court decision or statute in your jurisdiction. As I'm going to keep saying this over and over, consult a local attorney specializing in mental health law before treating a minor without parental consent. And recognize that you're risking becoming a legal test case. Oh, wow, that's hard. It's hard to read, but that says Belcher versus Charleston Area Medical Center. Unfortunately, I didn't notice that it was, anyway, it was not in a sufficiently contrasting font. But in 1990, the US Congress passed the Patient Self-Determination Act, which advanced adult patient involvement in decision making. In 1992, the West Virginia Supreme Court extended the Patient Self-Determination Act and defined a mature minor exception to parental consent. Again, West Virginia. If you don't live in West Virginia, this may or may not apply, right? They listed 7 factors for consideration, which are listed here on this slide. If you are going to consider treating a minor without parental consent, you should document at least one consultation with an appropriate professional. And I would argue that one of those appropriate professionals should be an attorney specializing in mental health law. At least one consultation with an appropriate professional, and consider each of these 7 factors at a minimum. Because even though this is just a West Virginia Supreme Court decision, it has been cited in court cases in other states. And again, you don't have to make, we're not required to make the right decision. We're required to have a reasonable process of decision making. Doesn't necessarily protect us from becoming a test case. Remember, this is tricky stuff. Consult an attorney specializing in mental health law, and remember that no prudent practitioner wants to be a legal test case like the Charleston Area Medical Center here. All right, somebody said, what do you do if the child has required social work services on his IEP, but the child, typically adolescent, does not want anything to do with it? Again, we have to operate within the systems we work in, but each of the codes of ethics, at least the ones that mention the word assent, require us to seek the minor's assent and to evaluate what the minor wants. But we're not legally required to do that. Again, that's that legal versus ethical issue. If the age of consent is 14 and a 15-year-old has divorced parents and is being brought to therapy by one parent, is it sufficient for the therapist to only obtain consent from one parent? Maybe. It depends on what the divorce decree says, because the divorce decree is going to contain a parenting plan or something like that. Some states have different names for it, but the divorce decree is going to state who has decision-making authority with regard to that child. So very, very often, even though the judge is looking at 2 people who clearly hate each other, will still issue a decree that requires those parents to work cooperatively to make things like medical and educational decisions. I find it puzzling. I'll just call it puzzling. All right, I have a bit more faith in this compendium of state and federal laws, though now that I think about it, I don't know why exactly. I guess because, well, it's curated by the National Center for Youth Law, and I did check a few states and found no errors. Though it's important to remember that I'm not an attorney, and am not an expert on these laws. The compendium was last updated in August 2024, but it links to a separate page with key updates as of January 1st, 2025. But probably the most important thing, and you can't read it, so I'm going to read it to you. Please note their disclaimer at the bottom here. By the way, the bottom of the slide is not the bottom of the web page. It's just what I was able to capture. But the disclaimer at the bottom, the information contained on this site is provided for informational purposes only and should not be construed as legal advice on any subject matter. So consult an attorney in your jurisdiction. Even if these maps aren't fully accurate, they can give us a starting point for researching the laws in the states in which we practice. And it's one of the reasons I like this, because it does link to some narratives that give you more information, and including information about where you can look for more information. Another tricky area is when kids are in state custody. I have learned not to believe caseworkers, foster parents, probation officers, etc., when they claim they have the authority to consent to treatment. I have been both a caseworker and a foster parent, so I'm not implying they have malevolent motives, only that they might be misinformed. They might simply be wrong. As usual with such matters, I advise practitioners to consult an attorney specializing in mental health law. Yet another big question in this scenario, and yeah, we're still talking about the first scenario. Who's the client? I told you this stuff is complicated. Is it the 14-year-old boy, the mother, the court system, the probation officer, the third-party payer? The American Psychological Association's ethical guidelines say that psychologists attempt to clarify at the outset of the service the nature of the relationship with all individuals or organizations involved. This clarification includes the role of the psychologist, for example, therapist, consultant, diagnostician, or expert witness. So they are acknowledging that these are separate and distinct roles. An identification of who is the client, the probable uses of the services provided or the information obtained, and the fact that there may be limits to confidentiality. That last point is especially important because some participants may have no right to confidentiality at all under the law. For example, if the boy is the patient, the mother may have no right to confidentiality, especially against demands for information from the other parent. All of this must be clarified at the start of therapy and re-clarified as needed. As usual, the ACA guidance is somewhat less directive, but says essentially the same thing. They do provide the additional instruction that in the absence of an agreement to the contrary, the couple or family is considered to be the client. I take that to mean that both the boy and his mother might be considered clients from an ethical perspective, unless agreed otherwise. That may not be the case from a legal perspective. I know that third-party payers often demand that we identify a primary patient when working with couples or families, but that is more procedural than legal or ethical. Most standards apply regardless of whether or how we bill. Somebody asked, how much should it cost to consult an attorney in such case? You got me. I think it largely depends on the market that you're in. Like for example, if you're in New York City, I suspect you're going to pay a bit more for legal consultation than you would here in Idaho. But yeah, I don't even know how to answer that. ACA Standard A8 regarding working with multiple clients refers to a relationship. I suspect that most people read that as a family relationship, but that is not the case. It surely could include parents, siblings, and other family members, but it could also take in probation officer, judge, etc. We also must think about what happens when we are asked to play potentially conflicting roles. For example, I would argue that it is not possible or ethical to seamlessly transition from therapist to expert witness, as would be the case if a therapist was asked to conduct a child custody evaluation after providing counseling to the client. At the very least, it is almost certain to damage the therapeutic relationship. I'm going to try to read some of this. If a state has a law that a minor of a certain age can consent to their own treatment, is it true that if the client signs the consent to treatment form, that they are in control of their treatment records, e.g., who information can be released to, and don't need consent from either parent, regardless? Um, these kinds of questions, I'm going to answer every one of them the same way. You need to consult an attorney in that state because it always comes down to the details. So, for example, in my experience, a child might be able to consent to the treatment, but that does not affect the parent's right to access their records. And it also doesn't stop the parents from objecting to the treatment. If not family therapy, would the mother be the client? Don't know. It's from an ethical perspective that comes down to negotiating, but from a legal perspective, don't know. It depends on the specific laws in the jurisdiction. Someone says utilize the risk management department of your malpractice insurance. They have a vested interest in not having you take risks, and that is excellent advice. Your malpractice insurance should cover legal consultation. Again, read the disclosure page on your insurance, because some does, some doesn't. Some policies do, some don't. All right, I'm going to move on to, well, all right. In this scenario, counseling is not yet mandated, but the mom thinks it will be. Once it is, the therapist should reopen the discussion of roles and confidentiality. This is actually one of the things that makes working with kids so much more complex than working with adults. Because we have to keep renegotiating this stuff. We have to keep clarifying these roles. And I guess one of the difficulties here is there's rarely an attorney in the room to help us do that. I find it best to do that after the client's initial meeting with the probation officer. Ideally, I prefer to meet with the child, the parent, and the probation officer so that everyone is clear on the nature of the anticipated services, including whether the services are court-ordered or mandated, and any limits to confidentiality before proceeding. All right. I guess this is a good place as any to stop and ask if anyone has any questions. There were questions in the Q&A, and okay, one was, do you have any suggestions on how to develop a consultation network as a professional? Yeah, I do, because I've done this in the course of my career. One of the things I've done is I've put out an offer of consultation groups for free, typically lunchtime. This was pre-COVID, where we could get together somewhere and have lunch together and just talk about cases in kind of an informal way. Also, as anyone who says they're anyone who says they're doing DBT, Marshall Linehan's dialectical behavior therapy, that's actually a requirement in the DBT model of consultation. So I've actually used that and put out the word that, hey, I'd like to sponsor a DBT consultation group, and people have. I'm not going to say we've had massive crowds, but people have taken advantage of that, because the truth is, like, for example, using DBT, if you're saying you're doing DBT and you're not doing regular consultation, an argument can be made that you're misrepresenting the approach to therapy that you're using. I have a 9-year-old client who's being treated for behavioral issues co-occurring with ADHD. There's police involvement as she banged her head too hard, and police had given her family a last chance to work her issues before they think she can be taken to asylum. Is there a legal angle I should focus specifically? I don't know about specifically, but I think everything we've talked about here applies. Consent versus assent. Um, we're talking about forced treatment. Again, I would want to have I would want to form a close personal relationship with a at least a risk management professional, but probably an attorney. Another one, a 13-year-old girl was seeing an intern. There was one previous suicide attempt. The girl told her therapist she was thinking about hanging herself. The therapist believed the child should be hospitalized, but waited until 2 days later to inform the parents after she had consulted with her supervisor. It was too late. The child hanged herself the night before. And I would say that that therapist and her employer probably have a good deal of legal involvement in their future, potentially, because yeah, that's not exactly specific to this presentation, but yeah, that kind of delay. Um, the truth is, if you look at the research, we kind of suck at predicting suicide risk as a profession in terms of mental health. But somebody specifically tells you, and they tell you that they have a specific plan, you really can't wait 2 days. Okay, I'm going to move on. But again, if you have questions, please do put them. Oh, I've got one. I got to remember to check different boxes. Okay, I got that one. All right. All right, case study 2, divorcing parents. Father brings in his 10-year-old son for counseling. Parents are in the process of a highly contested divorce. Boy lives with father, who reports he has sole custody. Father, father requests that therapist not discuss the custody matter with his son to avoid upsetting him. Father says he does not want mother involved in the counseling sessions because she has been abusive to himself and the boy. Mother leaves several messages for the therapist saying she wants to be involved in counseling. The therapist does not return those calls because he believes father has sole custody. Father states that his wife is unfit and makes disparaging comments about her, but never in front of the boy. Father asks therapist to write a letter to the court supporting him in the custody matter so he can maintain sole custody. Again, imagine that this therapist has come to you, lucky you, for peer consultation. Click chat at the bottom of your screen and share your thoughts on the legal and ethical issues presented by this scenario. What would you want to know? What would you ask this therapist? What concerns do you have? Because I abhor silence in a training, I'm going to start, but would imagine that there are going to be some responses coming in. First question is, again, who is the patient? And what is the therapist doing for this boy? What are the goals of treatment? What is this parent asking for? Would this only be okay if one of the parents has the sole custody, documentation on custody? Yeah, custody, it's going to be really important to know. It is extremely unlikely in most states that under the circumstances described here, it's really kind of unlikely that the dad could have sole custody, sole legal custody. But in my experience, it's unlikely. So yeah, I would want to see some kind of a custody order from a court saying that the dad has sole custody. Also, the boy is 10 years old. Again, remember Dr. Erickson's, anyway, the boy is 10 years old, a concrete and inflexible thinker, very susceptible to indoctrination, and he's having no contact with his mother. Yeah, what has made her unfit? What do we actually know here? What proof is there that father is telling the truth? All really good questions that a good peer consultant should be asking this therapist to think about. Though parental alienation syndrome isn't a real syndrome, it was, after all, invented by an attorney. After all, it still happens. The therapist should, yeah, that therapist should ask for documentation to support the sole custody claim. Okay, and I would argue, okay, here, I would want to be clear that I would not treat the child without contact with the mother. But again, that would depend on if the father is telling the truth. If he really does have sole custody, party on. But we don't know that at this point. I would argue that even if the father does have sole custody, the therapist can and should call the mother back. The therapist may not be able to tell her anything, but you can listen. You may gather information from the mother by calling. Um, yeah, somebody commented that. By the way, the way this works is the moderator is pulling things. Or, I'm sorry, the admin is pulling things from chat and then putting them into another chat. So I don't get to see who is asking the question, which is why I say somebody asks. Says nothing about the client. 10-year-old son wants just the father's, right? Who is the patient? What is the therapist doing for this boy if he is the patient? Um, the therapist could not write a letter if she has not met and assessed the mother. Hold that thought. First, before seeing the client, the custody decree must be provided to the therapist. I 100% agree. I would refuse to work with this boy until I had seen until I'd had a chance to make a copy of the custody order for the file. Has the alleged abuse been reported and verified? Again, we don't know. Somebody wrote, writing a letter, malpractice lawsuit. Again, hold that thought for a moment. And then my last point here is again, as the peer consultant or supervisor, because I've been in this situation many times over the course of my career, I just make a really clear statement. The therapist should not offer an opinion on the best interest of the child without conducting a full custody evaluation. I'm gonna skip forward to the outcome. Unfortunately, the therapist did write the requested letter. As you can see, it did not work out well for the therapist or the family. And I'm going to go back so we can actually ask this. What are the most important ethical principles? Again, as the peer consultant, what should you be asking your peer to think about? Again, let's use the chat box for that. And let's see, what if we are an intact family unit and there is no divorce? You typically still have both parents sign intake paperwork. Okay, honestly, I'm not completely obsessive about that, but I think if an attorney was doing this presentation, I think an attorney would say yes, that you really should get both parents, because how do we know it's an intact family? Now, I really like when I'm working with kids, my preference is for the first session, I want both parents present for the first session so that I can talk about confidentiality and the limits thereof and treatment goals and all of that. Ideally, both parents. That's what works best. But on a practical level, it's not always possible. Does the therapist have a lawyer to consult with regarding the potential of speaking on behalf of the child in court who needs, okay, in the case that we're talking about, case study 2, no, this therapist clearly did not consult an attorney. I'm sure an attorney became involved later. In fact, I know it did, because this is actually a case study that I took from my malpractice insurance provider. Because they publish this stuff on a regular basis. Because as someone pointed out, they have a vested interest in preventing us from doing stuff that will get us sued. Let's see. We have monthly reports of clients' progress for parents when they want letters, because we are not obligated to do that. Well, you would be obligated to do, well, I don't know about monthly specifically, but so for example, here in Idaho, again, I mentioned this, they passed the law July 1st that it's about basically parental rights. And an argument could be made that if you're not keeping the parent informed, you don't really have consent for treatment. And that law actually includes what I consider to be a bounty component, which makes it possible for parents to make money or family members to make money by suing the therapist. So we really need to take that seriously. Um, okay, someone said we refer these cases to forensic psychologists. Again, hold that thought because yeah, a lot of times when we start getting into these kinds of complex issues, like I will jump ahead a little bit. I never do. I am trained to do child custody evaluations. I never do them because they're just too risky. And frankly, I've never seen a case where, I shouldn't say never. I rarely see cases where child custody evaluations are actually helpful to the child, but we'll get to that. All right, so on the question at hand, which is the common ethical principles, we have non-maleficence, veracity, and justice. And yeah, absolutely. I was once told by a lawyer that we shouldn't review custody agreements because it could be construed as interpreting the law and working outside our scope, and that we leave it up to believing the parents. Um, okay, I'm not a lawyer, so I'm not actually competent to have an opinion on this, but frankly, I would find another lawyer because basically the lawyer seems to be recommending flying in the dark. Um, yeah, legally, interpreting, but anyway, again, I personally would consider that bad advice. But again, I'm not a lawyer, and there may have been more to that. Um, Someone else said veracity, justice, beneficence, non-maleficence. Did dad report the alleged abuse? If not, why not? Yeah, those are really, really good questions. As far as the common ethical principles, we have autonomy. The mother's autonomy was clearly trampled here. And again, we can see that from the outcome of the case. Non-maleficence, as indicated by the therapist's negligence, did a lot of harm. Um, Justice, the therapist failed to treat equals, the two parents, equally. That's almost like a slogan with regard to justice. Fidelity, we could also talk about the therapist's lack of fidelity to the values of their profession. We have had cases where parents have subpoenaed a child's record for use in a custody case. We have fought release due to damage to the therapeutic relationship. And again, the extent to which we can do that varies by state. Although HIPAA privacy rule has a little bit to say about that as well. So again, it always comes down to, by the way, I've actually fought subpoenas on the grounds that they were just really poorly written. And that can be valid. One thing that you don't ever want to do is ignore a subpoena, because in most states, a subpoena is equivalent to a court order, even though it's not written by the court. It's not issued by the court. So we need to respond to subpoenas. We can't just look at it and say, wow, this subpoena is so poorly written, I can't make sense of it. We still have to respond to it. Competence is not listed as one of the ethical principles by Childress and Beauchamp, but I suppose it can be seen as part of beneficence. If the therapist had more and better training, she might have known better than to involve herself in a child custody dispute. Okay, we've already looked at this. Moving on. Okay, we've talked about child custody evaluations. It's kind of a big thing for me because it has come up so many times over the course of my career. It is important to, I'm sorry, I just jumped ahead. Yeah, no, I didn't. All right, it's important to inquire about the marital status of a child's parents, as many of you have pointed out in the discussion, and to obtain a copy of any child custody order or parenting agreement. Even if you accept the idea that this attorney presented that you're not competent to review it, you can't have an attorney review it if you don't have a copy of it. And if you don't have a copy of it, an argument could be made that you did not do what attorneys call due diligence. It is also important to be explicit about the goals of treatment. Does the parent want counseling for the child? or are they seeking a custody evaluation? I need to know that at the outset. I would argue that those two goals are antithetical to one another. As I said before, I don't think it is ethical for a therapist to transition from therapist to expert witness, as would be the case if the therapist started out doing therapy, then switched to conducting a child custody evaluation. For one thing, the minor client is likely to tell a therapist things they might not tell an evaluator, and that creates both consent and assent issues. Many states have specific standards for who can conduct child custody evaluations, their format, etc. Some do not. For example, here in Idaho, literally anyone can write a child custody evaluation for submission to the court. It's left up to the judge to determine whether they were actually competent to do that. If you are asked to write a letter or to testify on behalf of one parent, decline. Just say no. Unless you have conducted a formal custody evaluation. At the very least, you must meet both parents. The bottom line is, do not do a child custody evaluation if you do not have specific training. I do have specific training, which is why I always decline. Here are the APA guidelines, American Psychological Association guidelines for child custody evaluations. There are only 14 of them. That's not bad, right? Note that just being a psychologist is not enough. They require that the psychologist gain and maintain specialized competence, though they don't define exactly what that means. Someone commented that they refer these cases to a forensic psychologist. That kind of implies this kind of training. I'm troubled by the father's attempt to control what is discussed with the child in session with the counselor. Me too. If there was suspected or alleged child abuse, then the therapist would have been required to contact Child Protective Services. Again, absolutely true. We are mandated reporters in every state and territory. Whether that always happens is another question. There's still the possibility for bait and switch from parents. Ray, whether parents are seeking therapy for the, oh, absolutely. Yeah, I've many times had parents come in and say, nope, I'm not going to ask you to testify. All I want is for you to provide my child with support as we go through the divorce. And then they show up down the road and ask for a letter or an evaluation. For parents that have split custody and a parenting plan, would you bring both in for an intake, or would you call the non-present parent for their insight? For my policy, maybe yours too, a subpoena triggers my legal defense coverage and they take care of all of this. Yeah, once it becomes litigation, things change dramatically. As far as whether I would bring both parents in, oh, I'm sorry, that was two different comments. As far as whether I would bring both parents in person, that's something I kind of play by ear, because I go by which, the parent who brought the child in the first place, they're going to start to give me some clues. But then, yeah, I will contact the other parent, and sometimes they'll say, no, we do not want to be in the same room. In which case, I also used to do a lot of child custody mediation, and so I'm very familiar with Henry Kissinger style negotiation, where the parties are never in the same room. We always involve our malpractice insurance when we get a subpoena. Yep. And this idea who can help to squash, negotiate another solution, etc. Another thing I've done just on a practical level is that I'll reach out to the other parent and notify them that we've been served with a subpoena. Technically, they're supposed to be notified that we've been served with a subpoena, but that doesn't always happen. And sometimes the other parent will move to quash the subpoena. So this is why we consult an attorney, because an attorney, we're counselors. At no point well, we're not all counselors. We're counselors, social workers, psychologists, we're addiction counselors, we're all kinds of people. But I am almost certain that at no point in any of our training did we ever hear the word quash. We're more likely to have heard that on TV. Attorneys, on the other hand, they live for this stuff. What about divorce mid-treatment? Yeah, happens. Parents had both been involved and married, and mid-treatment begin divorce custody proceedings. That, again, in my opinion, not a lawyer, not an ethicist, that calls for a meeting, maybe with both parents together, maybe with the parents separately, to get really clear. Again, the APA, American Psychological Association guidelines about being really clear about the role that you are playing. By the way, one of the reasons I use these different codes of ethics is that to some extent they can all be applied to our work. You don't have to be a psychologist to hear about the standards of the APA in a courtroom. Okay. APA. All right. So we're looking at the APA guidelines. All right. Here are model standards of practice for child custody evaluation of the Association of Family and Conciliation Courts and of the American Academy of Matrimonial Lawyers. I mentioned these folks before. The AAML standards are 43 pages long and pretty much impossible to summarize the way I did with the APA standards. The AFCC's model standards for practice are only 26 pages long, but they're equally dense. Both were written by attorneys. I think the AFCC attorneys and judges. So they do not make well, they make great bedtime reading, but they're very dense with lots and lots of legal verbiage. Yeah, don't go there. All right. Neither the ACA nor the NASW say anything about child custody evaluations, but both address the question of competence. The ACA requires the counselors practice only within the boundaries of their competence based on their education, training, supervised experience, state and national professional credentials, and appropriate professional experience. Several organizations train, several organizations, I thought I had a separate slide for this, but anyway, several organizations train and or credential child custody evaluators. For example, the National Board of Forensic Evaluators offers the Child Custody Evaluator's Certificate, which requires that the candidate already be a certified forensic mental health evaluator. That requires 8 hours of training and 40 hours of experience and an exam before they complete a 30-hour child custody evaluator's certification training course and pass another written exam. Part of the testing procedure for this is submitting an evaluation that is reviewed by a board. If you offer an opinion in a child, and I promise, I think this is the last time I'll mention this because I know I'm kind of beating this child custody evaluation thing to death, but if you offer an opinion in a child custody dispute, someone is likely to be unhappy. Such a person might make a complaint to your licensing board. That person, who already has an attorney, might just sue you as well. To paraphrase the late Nancy Reagan, just say no to child custody evaluations. Okay, someone asked, if parents have joint custody, one parent does not consent, that means that we are not able to provide therapy to the child, correct? Again, consult an attorney, but my knee-jerk reaction to that question is no. No, we can't. Now there's a difference. If one parent has consented and the other parent hasn't objected, you might be okay. But what if that other parent doesn't even know about the counseling? This is why we have to reach out to the other parent. We have to make sure that both parents are aware that this child is in counseling or therapy or whatever it is you do. Okay. I should stop asking questions as they come up. Otherwise, I won't have any to answer when the question slide comes up. But anyway, all right. All right, so case study 3. A therapist has been working with a 13-year-old boy for about 6 weeks. He is diagnosed with moderate depression and childhood onset conduct disorder. due to lying and, quote, conning, aggressive behavior towards peers, and fire setting, which started shortly after the death of his mother when he was 8 years old. These behaviors have continued at home, school, and in the community, and the boy is on juvenile probation. The father is frustrated and increasingly punitive. He has no family support. He worries that the boy has 2 inches and 40 pounds on him, so the kid's bigger than the dad. The teen has only recently started to open up to the therapist. Today, he reported that his father spanked him so hard it left marks on his butt. He does not want the therapist to report to Child Protective Services because his previous therapist reported, and that didn't help. It just made my dad mad. The boy is afraid of being placed in foster care. The father had not disclosed previous CPS involvement. Again, same deal. Imagine that this therapist has come to you for peer consultation. Please share your thoughts in the chat box. What are your questions? What do you want to know? As we've already discussed, therapist is a mandated reporter in every state. And in most states, the way the laws are typically written is if we suspect child abuse or neglect, we must report. So in this case, the child told you that the dad has hit him hard enough to leave marks. Yeah, somebody else commented to mandated reporter. Um, let's see. Therapist doesn't actually know that the boy is telling the truth, but does have reason to suspect that the boy was abused. Again, I would hope that everyone here knows that you're not going to ask the kid to show him your butt, show you his butt, so that you can confirm that he in fact has marks. By the way, no, I'll hold that. Mandated reporter, report and follow up on previous report if able. Let CPS decide. I always tell clients about duty to warn before we start therapy. So I would have told the child, yep, would want to talk to dad about CPS involvement previously. Yes, report and also talk to father about previous CPS report. Although we have to be careful about doing that because we don't want to be accused of interfering with a CPS investigation. So we really can't, under these circumstances, tell dad, "Hey, I'm about to make a report." I've had circumstances where the parent has reported something to me, and what I'll do then is I'll say, "All right, here's what I want to do. I want you to report this to CPS right now because it will look better for you if you make the report. But if you don't, I have to." And then very often I will sit there with the parent while the parent makes the report. And then I'll follow up because I want to make sure that it was actually CPS on the phone. Let's see. Has the therapist explained that they are a mandated reporter? In this case, I can absolutely tell you that the therapist did because I was the therapist. So yes, the child was aware that I was a mandated reporter. If the residing state has laws against physical discipline, yeah. But again, it's not my job as the therapist to decide whether that constituted abuse. If I have reason to suspect abuse or neglect, I'm mandated to make a report. Therapist has to report, but can talk through what that means with the client. Yeah, absolutely. And work through those anxieties about foster care and that kind of thing. It is not suspected, but the child told him. How do we know if the child is telling the truth? Again, we don't. But again, if we have any reason to believe, in most states, the states I'm familiar with, the law is pretty clear on this. Should we ask the dad if CPS was ever involved? Again, I think that's going to be something that we're going to have to play by ear, because is there going to be a way to ask that without disclosing that the child has made a report to us? Discuss your role to report abuse, try to maintain, yeah, absolutely. Talking to the parent puts him more at risk, possibly, yeah. No matter, it needs to be reported. Also, I would be working with the clinician on diagnosis, as it seems he has trauma. I'd also want to know what state the client is in. In Virginia, you can spank the third report made, which finally, yeah. All right. But again, it varies from state to state, which is consult an attorney. And really, if it's not abuse in a state, report to child protection anyway, because it protects you from potential legal liability. Therapist, okay, reporting. Okay, we have nailed all of my bullet points. So moving on, what are the ethical principles here? Again, as the peer supervisor, because I'm sorry, peer consultant, and actually that ends up being an important distinction. If I'm the supervisor, if I'm consulting with a therapist as the supervisor, it's my job to teach them things like these 6 ethical principles. If you're the peer consultant, it's not, right? You do not have a duty to teach this other therapist. You're being asked to consult, and so you should be asking questions. All right, so let's see. I would want more details regarding the spanking incident. Again, I would want more details about the spanking incident, but if I'm going to report it to child protection, I'm not going to ask for more details. I'm going to make the report, because I don't want to step into. I'm okay. I actually am trained as a forensic interviewer, but that's not my role with this child. All right, my role with this child is to be his counselor. So I'm not going to conduct a forensic interview. I'm going to leave that up to Child Protective Services, to have someone who's actually in that role to do it. Okay, one time when I reported abuse, I was the 3rd report made, which finally prompted an investigation. Big court case, an offender is serving time. Sometimes reports need to stack up to prompt investigation. And that is true, but not really technically how it's supposed to work. Again, speaking as someone who's been a forensic interviewer, I would want more. Yeah, all right, already read that one. All right, so justice, the therapist is legally obligated to report. Autonomy, the boy does not want the therapist to report. So this is a place where one of the ethical principles is in conflict with another. All right, and that other might be beneficence. Prevention of child abuse and neglect is considered a good, beneficial. Non-maleficence, the boy is worried that CPS involvement will make things worse. On the other hand, the therapist is obligated to prevent harm, and it sounds like maybe there's an escalation here in the level of violence in the relationship between father and son. Fidelity, reporting is likely to damage the therapeutic relationship with the boy and with his father. And then veracity. Veracity may come into play if the therapist has made promises of confidentiality without fully discussing mandatory reporting laws with the minor. So I was once provided, now this didn't become a horrible thing, but I was meeting with an intern for supervision. This is years ago. And the intern, I asked her to role play her initial session. And she basically told me as the client that anything we talk about is confidential. So we had to talk about that. It's just like, no, you can't make that promise, because there are exceptions to confidentiality. All right, let's see. Okay, somebody asked, will you please go over again if you would talk to the parent prior to reporting child service? No. Yeah, I'll go over it. It depends on who makes the who's reporting to me. If I'm sitting there talking with the child and the child makes a report, no, I am absolutely not going to talk with the parent before I report to child protection, because that would be potentially interfering with the child protection investigation. If it's the parent sitting there telling me, hey, I spanked my kid so hard that it left marks, and apparently I'm not in Virginia, um, then I'm going to say to the parent, I am a mandated reporter. I have to report this, but I would prefer if you make the report. Because what I'm doing by doing that is I'm maintaining, or at least attempting to maintain, the therapeutic relationship with the parent, and maybe making it somewhat less likely that I'll lose contact with the kid. Um, or I've actually been in this situation where I was not the child's therapist, I was the parent's therapist, and the parent revealed abuse. And again, my preference is to have the parent make the report in my presence. And then, because I'm a mandated reporter, I'm still going to make a follow-up report, because I want to be on record as having made a report. By the way, I've had therapists tell me that they call and they make a report, but they do it anonymously. I can't think of a polite way to say this, so I'm just going to say that's stupid. Because as a mandated reporter, you want a record of the fact that you made a report. All right. Anyway, all right. Moving on. All right. As I said, I was the therapist in this case. I did obtain the boy's grudging permission. I think an argument can be made that this was a really smart kid, honor student, and all that. I think he knew that I was going to have to report. I think he understood that. But anyway, I did obtain his permission. I made a report to CPS. I already mentioned this, but believe it or not, the investigator asked me if I had seen the bruises, despite the fact that I had told her their location. Because CPS reached out to the probation officer at my request, the father was not allowed to pull the boy from counseling as he had done in the past. Because I obtained the boy's permission before reporting, he wanted to continue counseling. The father was ordered to take parenting classes and anger management therapy, which ultimately addressed his childhood trauma issues. Somebody commented that they would want to know about this boy and his trauma. Well, the father had a pretty substantial trauma history himself. The father-son relationship improved dramatically over time, and the boy recently graduated from college. But it's kind of like, anyway, whatever. So this is good stuff. It was a good outcome. The boy didn't end up in foster care. So they don't all end that well. Okay, case study 4. It's 11:39. All right, we're I think we're doing good. What slide are we on? 57. All right, not bad. Therapist is seeing a 15-year-old girl with a history of suicidal statements and self-harm, cutting. Identifies as LGBTQ plus, is diagnosed with moderate depression and an autism spectrum disorder, but is convinced she has borderline personality disorder based on a TikTok video. After about a month, client reveals that they are trans and wants to be called by a male name, lives with mother and stepfather, and is not yet ready to come out as trans to them, though mother has been supportive of their, quote, queer identification. Spends weekends with the biological father, who, by the way, has a bipolar diagnosis, who reportedly makes no demands and never says no to anything. Not surprisingly, he is supportive of their gender transition. This one's longer. Mother phones therapist regularly. In order to respect the client's wishes, therapist uses the client's dead name and female pronouns. Client acknowledges frequent suicidal thoughts but denies intent or plan. Says they are cutting. They use cutting as a coping strategy when the suicidal thoughts grow in intensity. Client is a straight A student, except for PE, because they refuse to dress down. Client has a girlfriend, who was comfortable in a lesbian relationship and is supportive of their transition to male. It is unclear whether mother knows about the girlfriend. Here we are again. Once again, imagine that this therapist has come to you for peer consultation. In the chat box, what do you want to know? What do you want? What do you want this therapist to think about? As before, just to save time, I'm going to kind of start the discussion and let the the chat catch up. Consent. The mother has not consented to treatment for gender dysphoria. Now, in this case, again, I was the therapist, so that's okay because I was using a DBT approach. So one of the basic the treatment priorities in DBT are such that if there's any suicide or self-harm, that's what you focus on. You don't work on anything else until those issues are resolved. So as long as she's cutting, I'm focused on the cutting. But if I was to jump into talking about the gender dysphoria, I'd be doing that without parental consent. Let's see. Concerns about cutting during suicidal thoughts. Are they sexually active? Again, in terms of my approach to this client, I'm going to stay away from that. But yeah, it's a reasonable question, especially because it opens the question of other potentially risky behaviors. How comfortable do you feel with discussing gender transition? And yeah, if we actually get through all these slides, we're going to talk about that concept or that issue of how comfortable therapists are with gender transition. And there's also competency issues with that. You could be comfortable with it, but really not have a clue, because gender transition is huge. It's a huge issue. Consent and safety, working with a safety plan with the client, absolutely. Be careful about pronouns and clinical notes, absolutely, because the mother has access under Idaho law to this minor's full record. And this minor has not has not come out as trans to the mother at this point. By the way, they have since. The client presents high risk of self-harm and suicide. Therefore, it would be important to assess for suicide. Absolutely. Safety plan. Is borderline a definite diagnosis? I don't think borderline is ever a, a definite diagnosis. But well, okay. But in this case, no, not at all. She watched a TikTok video. I'm sorry, he watched a TikTok video um, that talked about quiet borderline personality disorder, which apparently is borderline personality disorder without symptoms. And I am a personality disorder specialist, so I do find that concept amusing. But no, this was a TikTok diagnosis, not an actual diagnosis. Could she harm anyone else? There were no indications of that, but again, good question, and it's definitely a good question for the peer consultant to ask the therapist. Please clarify the gender dysphoria without parental consent. All right, parent comes in and I don't remember whether I said, but all right, the parent brought this girl at the time in for treatment for depression. That is what the mother gave consent for, depression and suicidal ideation and and cutting, because she was aware of all that. So that's what her consent was. If you turn around, or if I had turned around and started treating this client for gender dysphoria, I would have been doing so without legal consent, because the parent doesn't know that I'm doing that. Um, yeah, some simply use their name, no she, her, or he, him, etc. Although sometimes that can get really awkward in a phone call. Self-harm, client is self-diagnosing, efficacy, suicidal ideation defies confidentiality, but not gender issues. Correct. Yep. Yeah, we have a duty to protect. But she has suicidal ideation, but it's part of my job as the therapist to evaluate the suicide risk. All right. Okay. Moving on. What are the most important ethical principles here? While we're thinking about that, I have a comment. I understand quiet borderline as without the raging behavior criteria being present as one who specializes in BBT, BP, BPD. I need to take a drink. Yeah, I would want to know if they're taking medication, drugs, etc. Is the therapist competent in addressing suicidality among LGBTQ teens, QIA teens, compared with their peers? You mean compared? Well, okay, you can't answer, but um, I was the therapist, and yeah, I think I'm competent to address those issues, but I guess that's an open question. Um, if the client disclosed other information after mother gives consent, you can't treat unless you get consent, which would out the client. The client has no rights. How old is the client? Um, the client is 15 years old. And as I already mentioned here in Idaho, if you're under 18, you have no legal rights under Idaho state law, at least in a healthcare situation. Uh, Client disclosed other information of, yeah, okay, read that one already. Substance intake history. Yeah, there were no substance issues identified, but we could certainly do that. And it's, again, certainly a reasonable question that for the peer consultant to ask. Okay, here's a maybe the truest statement of the day. The idea of getting consent for each topic the child brings up feels very complicated. Can we talk about this more? Yeah, it's basically the topic of the whole. But yes, we absolutely will. Someone says autonomy, non-maleficence, beneficence, and fidelity sounds backwards when it comes to patients' rights. I'm going to reserve comment on that because I have a slide later where I say reasonable people can disagree. I certainly have my point of view, which actually is probably pretty obvious listening to me, but I'm going to try not to be completely over the top with it. Autonomy. The essence of this principle is allowing and encouraging an individual the freedom of choice and action. Again, I would argue that under Idaho law, minors don't have autonomy anymore. Non-maleficence, the client is cutting. This is not suicidal behavior, which means it's not necessarily reportable, but again, under a DBT point of view, it is the focus of treatment until it is resolved. All right, I think we've talked about, veracity. The therapist is lying by omission, by dead naming and misgendering the client. But by doing so is maintaining fidelity with the client. So again, these ethical principles almost always act against one another to some extent. Let's see. Okay, privacy and confidentiality. Though many adolescents voluntarily share a lot of health information with their parents and other trusted adults, they are often especially concerned about disclosure to their parents or guardians of information related to sensitive care and activity. I've also found that a lot of times kids don't want things revealed to their parents because they don't want to hurt the parent. They will very often keep secrets to protect the parent from the secret, because they think, sometimes because they think that the parent is too fragile or whatever. But there are all kinds of reasons that a child might not want things revealed to the parent. All right. The American Counseling Association states that counselors should protect minors' confidences as specified by federal and state laws, written policies, and applicable ethical standards. This ACA standard actually creates a real dilemma for those of us who are in states that have laws like the ones I've been talking about here in Idaho. And I know Idaho's not the only one, because it's basically saying we're supposed to follow the law, but we're also supposed to follow applicable ethical standards, which in some cases is impossible. Someone asked the question, what's your advice when ethics and legalities conflict? I really don't know how to answer that, because ethics and legalities often conflict. The example that people often use is that slavery was 100% legal in the United States, but there were people who we now look back at as heroes because they broke the law to do what they considered to be ethical. I don't think there is a simple answer to that question. I don't even think there's a complicated answer to that question. It's why philosophy departments exist in universities. Therapists working with minors should be careful what private information they seek or accept, and should act to protect the minor's rights to privacy as necessary. Therapists should be equally cautious about what they include in their records, carefully considering the legal and ethical justifications for their disclosures. I would argue that what you write in your notes is a disclosure. So where the ethical guidelines talk about confidentiality and disclosure, because you know that you don't necessarily control who gets to read your notes, what you write is a disclosure. So we need to be very careful what we write. We also need to be very careful what we ask. Many states and school districts have created laws and rules giving parents complete access to all records of their child, including sessions with their counselor or psychologist. Reasonable, like I said this before, reasonable people can disagree on whether this is a good thing. But from the minor's point of view, this means they have no right to privacy. We should be concerned about this. We should be concerned about this because decades of research shows that concerns about confidentiality and disclosure can affect whether adolescents seek care, where they seek care, and how openly they talk with healthcare professionals. For example, kids might be more likely to talk with their peers or to influencers online than a therapist for this reason. Concerns that confidentiality will not be protected can lead adolescents and young adults to forego or delay care, or to be less than candid when they do see a healthcare provider. And that's not me. There's actually a reference for that one. I often stop clients, both teens and adults, and review the limits of confidentiality when I suspect they are about to make a disclosure and they might regret. I am also very careful what I put in my progress notes. I often use psychotherapy notes to document particularly sensitive information. What if a child is receiving treatment in a state where the minor has legal consent, but not in their state of residence? The laws that govern are the law basically come down to the state in which your butt, not your as the therapist, the client's butt is located. So that one I actually can give a fairly clear-cut answer to. I'm confused about autonomy versus consent. Yeah, me too. In Colorado, age of consent is 12. So does the parent still have to be informed and approve of the treatment goals? I don't know. That is a Colorado lawyer question. For example, if treatment switches to gender affirming care rather than the presenting issue, well, it comes down to who's giving consent in the first place. But again, the devil is in the details. Colorado law, and I don't know Colorado law. I don't, anyway. But Colorado law probably doesn't just say age of consent is 12. There are probably stipulations attached to that, just like in California, that kids that young can consent to treatment under certain circumstances. And realize I'm making this up as I, well, I'm not entirely making it up, but I would suspect that there are some other considerations here as to whether a 12-year-old can truly give consent, which is why we want to consult an attorney specializing in mental health law in that state to be certain. One question that attorneys have always advised me to think about is, who can sue you? So the law might say that this 12-year-old can give consent. The parent can still turn around and sue you or your company. Talk to a lawyer. All right, contrary to popular belief, the P in HIPAA does not stand for privacy. It stands for portability. Generally, the HIPAA privacy rule applies uniformly to all protected health information without regard to the type of information. One exception to this general rule is for psychotherapy notes, which are treated differently from other mental health information because they contain particularly sensitive information. They are considered the personal notes of the therapist, and to some extent are kind of an invention of HIPAA, of the HIPAA privacy rules. With few exceptions, the privacy rule requires a covered entity to obtain a patient's authorization prior to a disclosure of psychotherapy notes for any reason, including a disclosure for treatment purposes to another healthcare provider. That's important because the real purpose of HIPAA is to facilitate communication between healthcare providers. But again, the privacy rule includes exceptions to that. One such exception is for disclosures required by other law, such as for mandatory reporting of abuse and mandatory duty to protect situations regarding threats of serious and imminent harm made by the patient. Again, I feel the need to say state laws vary as to whether such a warning is mandatory or permissible. In some states, the warning is required, and actually requiring the law, or I'm sorry, requiring that disclosure makes the therapist safer than allowing it, because allowing it means that you had discretion. All right, let's see. Please say more about confidentiality with minor in relation with disclosing to parents or in supervision in cases where there is no concern for self-harm or harm to others. Please say more about. Well, again, it's gonna depend on state laws. If you look at the codes of ethics of our various professions, they say that we should do everything we can to protect clients' confidentiality. So basically, what it really comes down to, what it really comes down to is, are there laws that specifically require you to disclose certain information? Someone asked, what is confidentiality in state regarding substance abuse if identified? There is a whole separate federal law about confidentiality in substance abuse treatment, or is it a law or rule? It's law. It's in code, but it's kind of beyond the scope of what we're doing here today. Okay, our records are not necessarily privileged. We may have learned that in school, but disclosures may be required to protect clients or identified others from serious and foreseeable harm, or when legal requirements demand. So I always, as part of my confidentiality spiel during my first session, and then periodically throughout the course of therapy, I tell people one of the exceptions is a court order. So you should write every note, including your separate psychotherapy notes, with the assumption that third parties will read them and may have interest inimical, I love that word, to those of the client. I'm not going to go over the rules for psychotherapy notes. They're pretty arcane, but if you're going to maintain psychotherapy notes, um, consult someone who actually knows what, basically look at the HIPAA privacy rules, because the HIPAA privacy rules actually do a pretty good job of describing what that means. What is the difference between a psychotherapy note and a progress note, or general medical record. I'm kind of speeding up because we only have about 14 minutes. Counselors serving children and adolescents must balance. Yeah, why is this slide here? We already read this. All right. Anyway, responsibility. Bottom line. Oh, I know why. Because we have to balance our responsibilities to protect them from harm, while appropriately communicating and collaborating with the adults in their lives. So our codes of ethics, not just state laws, but our codes of ethics, define a responsibility to parents and legal guardians. And unfortunately, I sometimes run into people who see this as kind of an adversarial thing, and it varies. Many of the kids I've worked with, their parents have been completely supportive, have been wonderful assets to the kids, but again, not all of them. Practical issues. Nearly a third of Gen Z adults identify as LGBTQ plus. That is a significant increase in terms of different generations. This is likely higher among Gen Z teens, but it's hard to study due to privacy laws. There are states where there are these national surveys that they do. There are states where questions have been struck from those national surveys for political reasons, because they simply don't want to ask the kids in their state some of these questions. I have seen kids who did not identify as queer turn on adults who were not affirming, or at least accepting, of their non-conforming peers. One boy recently commented, "I don't trust him," referring to a school counselor, because of the way he treated this other kid who really wasn't his friend, as it turned out. He was just more of an acquaintance. Even if you don't see this as the justice concern it clearly is, it is important to realize that it is a fidelity issue, since it potentially threatens the therapeutic relationship, possibly before it has even started. The 15-year-old in this scenario revealed after about a month that he identified as a trans male. This might present as a values conflict for some therapists. Regardless of our personal values, ethical mandates consistently prohibit discrimination based on sexual orientation and require us to obtain training to overcome such competence issues. The ACA Code of Ethics, for example, it addresses this directly, saying that counselors refrain from referring prospective and current clients based solely on the counselor's personally held values, attitudes, beliefs, and behaviors. I've seen states where they have passed laws that directly contradict this, that basically define a right of a healthcare provider to impose their personal beliefs and values on their clients. Okay, I almost always have parents join at the end of my sessions with kids and teens and share with their parents what we addressed and are working on, with some limits, of course. This minimizes the occasions where I am the one who has to break confidentiality. Keeping parents informed also lowers your risk of parents making a complaint. I would agree with that 100%. Not every child is going to agree, though, with that. Not every child is going to be willing to have the parents come in. It depends on the relationship. All right. Similarly, the NASW, APA, and AAMFT codes of ethics prohibit discrimination based on sexual orientation and require practitioners to obtain appropriate study, training, consultation, and supervision. The APA code specifies that knowledge of sexual orientation is essential for effective implementation of psychological services. And the APA is not talking about psychological services to people who identify as LGBT. They're making that as a blanket statement. When confronted with values conflicts, 40% of therapists referred the client to another therapist, while 25% discussed the conflict with the client. Clients who have been referred to other therapists because of their sexual orientation have reported feeling discriminated against and as suffering psychological harm. Therapists need to understand that referring clients due to personal values is not a competence issue, it is discrimination. I agree with that statement, but that's not me. That comes from Matthews 2017, which is in the reference list. Okay, teens and young adults today live their lives online. They will almost certainly want to communicate with you via text message. If you want to freak out a teen or 20 something, just make them talk on the phone. They may want to friend you on social media. As far as I know, social work is the only profession with a specific social media standard, which means they define the standard of care for all mental health professionals with regard to this, at least for now. That standard is that you should have a written policy on social media. I would suggest that your policy should be a firm no. Do not friend clients on social media. I'm aware of several licensure cases that focused on communication over social media. You might choose to use text messaging for appointment reminders. I do, with the client's permission, but do not share protected health information in text or emails and discourage your client from doing that. The great advantage of a just say no policy is that it can be quite a bit shorter than this 60-page guide that you see on your screen. That the NASW social media policy is 60 pages long. It's not horrible reading. It was largely written by Rick Reamer too, by the way. All right, so I've been answering questions as they come in. I do see one that I don't think I did. Client, 10-year-old female, divorced parents. The client reports sexual abuse from father. Mother seeks therapy for client. The court stated that there is not enough evidence and ordered family reunification. The client is doing TFCBT, and family therapist stated I must stop my work with the client. The client disclosed to family therapist of SA. Huh. Do I have any advice? Well, all right. The therapist says you must stop. That's not really up to the therapist, is it? I would suggest meeting with the parents and the child, and hopefully this other therapist, and laying it out for them, and let them make the decision, because that's who's supposed to make decisions like that. All right. I'm going to move on in the hopes that in the 6 minutes remaining, I might be able to do a little bit of school law. Most children and adolescents spend, I'm going to skip that. All right, school's important, right? One of the important roles that we play is helping with school issues. The federal special education law is typically referred to as the IDEA, even though Congress renamed it it doesn't matter. Nobody in the public schools pronounces it as IDEA. If you do, it'll mark you as an outsider. So don't. It's the IDEA. The general intent of the IDEA is to ensure that children with disabilities have equal access to public education and are prepared for employment and independent living. One of the most important concepts in the IDEA is FAPE, which is also typically pronounced as a word by educators. So IDEA is, you spell it out. FAPE, you say FAPE. It stands for free and appropriate public education. Honestly, I was at a meeting once where a teacher said free inappropriate public education, and she was not kidding. She just didn't know what FAPE stood for. FAPE must include special education in the least restrictive environment. That's the law. And may include related services, transition services. I'm just going to skip some of those words. The meanings of FAPE and least restrictive environment have been largely defined by an amazing number of lawsuits and due process hearings. Because of that, every community, you're going to be able to find an attorney specializing in school law in pretty much any community. Another important concept, least restrictive environment, which teachers typically just say LRE, means that students should be educated in regular classes in their neighborhood schools unless that can't be done satisfactorily. It's never supposed to happen for the convenience of the school district. It's never supposed to be done to save money. It's supposed to be, it isn't possible to educate this kid in their regular school. So, so we are going to reluctantly put him in this special program over here. Other important concepts in IEP. Most of us have heard of an IEP and the IEP team. There are lots of rules regarding, whole books have been written about the IEP and the IEP process. It's really important for you to know that parents are always members of the IEP team, and they can invite anyone with some involvement in the student's life to attend IEP meetings with them. Over the years, I have attended a lot of IEP meetings, to the point where my local school district actually had some informal policies in place for when I showed up. Students 14 and older should also be included in the team, but I usually recommend that parents insist on including younger kids unless there's a really good reason not to. Okay, Columbo. Yeah, I love TV references. You do not have to be an expert on school law to be helpful in an IEP meeting. Ask lots of questions. You can learn a lot. Unfortunately, school personnel often use lots of educational jargon that even some other educators might not fully understand. Parents may be reluctant to ask questions. I often use the Columbo technique in meetings, asking questions to force professionals to clarify what they mean. And it really tends to annoy them because they know I do know the meaning. Anyway, parents, especially of younger students, may be emerging adults themselves. In any case, they are often younger than the teachers and administrators in the meetings and may be intimidated. Some may have attended the very school and may have even been special education students themselves. Okay, I said that already. Teachers will sometimes imply or say out loud that children should be medicated, most often for ADHD. Schools are not allowed to require that a student obtain a prescription for a substance covered by the Controlled Substances Act. But I have actually reported schools for practicing medicine without a license under those circumstances. But if such a medication has already been prescribed, the school may be allowed to require that the parents administer the medication as a condition of attending school. Again, this is federal law or rules. School districts are responsible for establishing, school districts are responsible to find the kids who need special education. They don't always do it. So I have this format that I actually used to have a sample letter that I gave to parents. And unfortunately, parents were just filling in the blanks and turning it in. And that was kind of a bridge too far for me. So now I just give them this list of elements that should be in such a letter. So feel free to use it. Don't, whatever works for you. Let's see. Some schools prefer to offer students a 504 plan instead of an IEP. 504 plans do not give parents and students the same range of legal and procedural rights as IEPs, which is why some school districts really like them. They may be appropriate for students who require only accommodations, but not special education. A 504 plan might, for example, provide a visually impaired student with textbooks in Braille. If the student needs to learn Braille, that would be special education and would call for an IEP. And I apologize, we're on slide 82 of 92. So we got close, right? You have access to the slides. I hope that you will avail yourself. For people who watch this on video, the test has questions on some of these slides after this one. So you're definitely going to want to review those slides. And I'm going to end it here because we are out of time. So, hey, and I really appreciate the questions and the comments because I love doing ethics training, but ethics training is deadly if it's just me talking. So thank you.
Thank you so much, John. I think that due to everyone's response, you made ethics fun and
Wow.
entertaining, and I think everyone wants more. So thank you for all of this great information, for engaging us with this informative discussion. On behalf of TPN Health, we'd like to thank you.
You're
To a
welcome.
reminder to all attendees, in order to receive your CE certificate, you must complete the post-session evaluation, and that will be in your account in the next couple of hours. And as John said, if you have to review the slides for those last questions, anyone who's unable to download them from the landing page here due to firewall issues, you can email support@tpn.health and I can get that to you. Thanks for everyone for attending, and thank you so much again, John.
You are welcome.
See
And
you
on behalf
later.
of Sandstone Care, thank you, John. This was amazingly helpful.
Cool. Glad to hear it.
Yep. Thanks. Thanks. Have a good day, everyone.